क्या चीज़ है 47?
For staying the execution proceeding.
For
For staying the execution proceeding, I will file.
47.
47.
It has been admitted. It has been admitted.
Yes.
The case is otherwise ready.
Your response are not responding.
No, they have appeared.
My notices have been issued by.
They have already appeared.
Appeared my notices.
It is under the heading for hearing.
My lords. And
So?
Notices have been served upon them, my lord. But even there is no response back.
They need not file any response. The case is otherwise ready. You are the appellant.
My lord.
What is the matter?
Not for this case relates to mutual transfer of the property, my lord. But without having any entitlement over the property of the respondent, my lord, they entered into the agreement for mutual transfer of the property property, my lord.
Cooperated.
My lord.
47 है?
My lord.
इसको कल कर। आइए तैयार होकर सुनेंगे। हियरिंग।
My lord.
आइए वही पे ऑर्डर नहीं होगा। बाकी तैयार हो गया, रिकॉर्ड आ गया, काफी है। आइए, आपको क्या बोलना? एक हम लोग का ऑलरेडी पार्टर्ड मैटर फिक्स्ड है, उसके बाद ही टेकन। क्या चीज का? आप कौन है? आपका वकील साहब नहीं है?
हम रिस्पोंडेंट पर्सन।
अच्छा, कौन सा केस?
ये मिनिमम वेज
इनका यही कहना है कि इनको रिस्पोंडेंट साइड से है, जल्दी सुन लिया जाए, उसके रिकॉर्डिंग को ये अभी आइए।
एडमिटेड है मैटर एडमिट किया हुआ है।
एडमिशन में है।
एडमिट नहीं हुआ अभी तक।
एडमिशन में प्रोसेस में है। पेटिशनर दिया है एडमिशन में। फर्स्ट हियरिंग
केस लिस्ट में है। फर्स्ट हियरिंग में नहीं हुआ।
नहीं।
इट इज अ मैटर ऑफ मिनिमम वेजेस एक्ट।
हाँ।
कौन है आपके अदर साइड के वकील?
दीपक भारती।
ये लास्ट ऑर्डर है।
इसी कोर्ट का एक ऑर्डर था 122/2024। आपने आदेश किया था कि 2 महीने में जो है गवाही कराने के लिए टाइम दे दीजिए, कोई दिक्कत नहीं होगा। 2 साल हो गया, वो गवाही नहीं करा पाए। फिर आए, जब बंद कर दिया गया तो फिर आए हैं कि हमको गवाही के लिए चांस दिया। ये लेबर डिस्प्यूट है, इसमें 3 महीने के अंदर जो है अवार्ड करके सरकार को देना प्रोविजन है। और सुप्रीम कोर्ट द्वारा कहा गया है कि 6 महीने के अंदर आप इसको डिस्पोज कीजिए। 5 साल हो गया, हमको नौकरी से निकाल दिया गया है, दर-बदर भटक रहे हैं।
कल सेकेंड हाफ में आप आ जाइए 2:15 बजे, ठीक है? यहाँ आइएगा, आपको सुनेंगे, क्योंकि फर्दर प्रोसीडिंग स्टेड है ना। वो मिस्टर दीपक भारती को उनको बुला लीजिए और बोलिए कि ये सुनेंगे कल। ये अलाउ कर दीजिए कल को 2:15।
From the supplementary list, under heading for fresh filing, item 1, DA.20.03 of 2026.
Before my lords of the father, is the daughter-in-law is supposed to have died in a well. In a well. Now, prior to this, this marriage, the marriage between the daughter-in-law and my son. Now, this has a history. They both eloped. Thereafter, the case was lodged by the girl, since there were some issues with respect to the marriage. Then marriage was solemnized, and thereafter she was taken. So that fact has been mentioned in the FIR, regarding the case number, that's 438 of 22. Four 38 of 22. Now, what is the
I think case diary would be
Ah.
suffice.
because place where I will be relying upon, place where the dead body has been found is a well which is away from that place. Then these statements.
Counsel for the state is directed to file a counter affidavit in this case. Office is directed to call for the case diary. Post on हम लोग कौन सा डेट देते हैं आज 9th April ना 9th April.
The heading for admission, item 2, BA 916 of 2026.
Counsel for the petitioner seeks permission to withdraw this application. This application is dismissed as the state dismissed.
From the daily list under heading for fresh filing, item 1, BA 1519 of 2026.
For the intermediate quantity, more than the small quantity, less than the commercial quantity loss. Is a recovery of 5 kg 160 grams from the 1.2 heavy Saturn channel. Seizure list is at page number 16 euros. Nothing has been withdrawn from the position of the petitioner, and on his statement, my name is transcribed to lordship, having no criminal antecedent lordship, and the co-accused from whom the data has been recovered has been granted bail by the Congress bench lordship by the next check to page 26.
You have any antecedent?
Yes, Lord.
You have any antecedent?
No, lordship. No antecedent. I have mentioned in para 19 page 7. Lordship.
Para?
19 page 7.
There is no recovery. Is there no recovery from you?
That is, we have not filed out a
In the impugned order, it appears that from your Pithu bag, while you were boarding the train, there was recovery of 5.160. This is false.
No, lordship. That has been wrongly recorded because lordship from the
Wrongly recorded.
lordship
The
from
counter
the
file करिए वो.
lordship in this case
The counsel for the
seizure list can be seen, lordship.
We'll see that. Counsel for the petitioner submits that it has been wrongly recorded in the impugned order that while the petitioner was carrying 5.160 kg of ganja in Pithu bag and while he was boarding the train, he was stopped by the informant and on search ganja was recovered from his possession and seizure list was prepared. Counsel for the state is directed to Counsel for NCB is directed to file a counter affidavit in this case and also produce the case diary वहीं से है. Call for the case diary from the concerned.
I mean, permitted to read only one paragraph from the impugned order, lordship.
अरे भाई NDPS का केस है, काउंटर नहीं देखे. आप अगर आप सही बोल रहे हैं तो सीजर लिस्ट नहीं है तो रॉन्गली रिकॉर्डेड है, बात खत्म है. फिर क्या?
Seizure list में तो लिखा है उनके बैग से कोई उसके बैग से कभी.
We'll see that. Right? There is a statement, you are making a submission, there is no recovery from you. Let them file a counter. 9th April. And along with the criminal antecedent. It will come on 9th April.
9th.
Item 2, BA 1550 of 2026.
मृतिका की मृत्यु होने के बाद में और डेड बॉडी के रिलेशन के बाद में इंफॉर्मेशन नहीं मिला था ये
Petitioner absent post-mortem. एक दिन खाली एडजर्नमेंट देते हैं, नेक्स्ट दिन भी नहीं आने से हम डीएफडी कर देते हैं. सिंपल सा स्टोरी.
Item 3, BA 1883 of 2026.
This under section 103(1) of Indian BNS, which is corresponding section 302 of Indian
come to his house and then found the door was locked and he made a call to his son. And then informed that
Informant
is the wife of the deceased and the father of the petitioner.
Informant बेटा है जो और बेटे का
बेटा
माँ
है।
है और
and
accused
father
का
has confessed before him.
There is extrajudicial confession, but there is no such corresponding wife or mother. Only it is FIR in which he is stated, but there is no corroborative evidence that whether he has confessed or not. Only that his statement is there in the FIR, and he is not the eyewitness. And
Any recovery?
No, nothing has been recovered.
Where was the body found?
It was outside the. It is outside the house.
there from 238 is there corresponding to 201. Causing disappearance of evidence or giving to false information.
It has been stated that one Tangi was also recovered.
And your confession?
Yes, that is my house. Along with it was along with the dead body. It has
From
stated.
the house it has been recovered. Since when are you in custody?
I am
It
custody.
is just it is
Which is the
क्या बोलना? एक्स्ट्रा जुडिशियल कन्फेशन, टांगी का रिकवरी घर से, इनके खिलाफ क्या स्पेसिफिक कैसा
स्पेसिफिक यही हो सकता है कि मोबाइल पर सीरियल दिया जाता है
हो सकता है ना?
तो वहीं पे एक जगह है
बेल दे देते हैं? He is not a criminal by nature, right? चार्जशीट तो हो ही गया ना आपका?
यस चार्जशीट
नंबर 1 एंटीसीडेंट भी होगा क्या बीवी को मारने का? एंटीसीडेंट इन सब केसेस में नहीं खोजा जाता।
बहुत सारा ये है।
BA number 1883 of 2026. Heard the learned counsel appearing on behalf of the parties. The counsel for the petitioner submits that the son of the deceased is the informant of this case, and it is alleged that his father has killed his mother. And Tangi was recovered from the house of the deceased. He submits that except extrajudicial confession, there is nothing incriminating against the petitioner, and he is in custody since 25/10/2025. The learned counsel for the state has opposed the prayer. However, he submits that the allegation is very serious. After hearing the learned counsel for the parties and considering the fact that apparently except confession and extrajudicial confession and the recovery of murder weapon from the house, and that there is no eyewitness to the occurrence, and the charge sheet has already been submitted. The petitioner is directed to be enlarged.
Item 4, DA.18.03 of 2026.
This is the prayer for regular bail law. In this matter, the certain sections, along with sections of IT Act, this is the case of cyber crime.
Case diary will be required.
One of the two accused has been found guilty.
Is this an answer to what I said?
Not just
Call for the case diary. The learned counsel for the state is directed to file a counter affidavit along with criminal antecedent report of the petitioner. The counter affidavit should specifically state the connection of the petitioner with the alleged crime, and if any victim has come forward to support the prosecution case against the petitioner. 9th April.
Item 5, DA.2151 of 2026.
May please. FIR under section 196 up to 1 corresponding section 302 IPC. Petitioner is not FIR is an unknown person and there is only confusion matter and self-confession and confession of other co-accused persons. Charge sheet has been submitted and trial has begun. Out of 8 PWs, 3 have been examined and they have not supported the prosecution case. I have alleged the deposition that starts from age 16 months. And I am in custody since last 18 months. Deposition. Informant has also not supported fully the prosecution case.
Will expedite your trial. How many witnesses are to be examined here?
ये out of 8 3 have been examined.
आपका ट्रायल एक्सपीडिएट ट्रायल आपका एक्सपीडिएट करा देंगे
18 months से custody में.
कोई बात नहीं आपका 6 महीना में आपका ट्रायल खत्म हो जाएगा ना
कोशिश करें.
5 विटनेसेस हैं
हाँ 5 months. ऐसे 18 months से custody में रहता है.
कन्विक्शन होगा तो कितना होगा कस्टडी आपको कितना कस्टडी होगा कन्विक्शन
एक 9
Life.
2024.
इसलिए 18 महीना बहुत ज़्यादा नहीं ट्रायल इज इन प्रोग्रेस
ठीक.
we will ensure that and there is direct allegation against you it's not that
Nobody has seen the outcome. All the 3 witnesses in the cross-examination, they have stated that they have not seen the outcome.
knife has been recovered from your possession
No, not from my position.
it has been
Yes.
mentioned in the order
Order should be mentioned.
इसमें लिखा है.
page number 24
जी.
knife has been recovered from the possession of the petitioner and the same has been seized by preparing a seizure list
हाँ, 1000 रुपये में पाए हैं.
जब सबमिशन सही नहीं होना तो हमारा दिमाग खराब हो जाता है इट्स नॉट दैट फॉर सीरियस ऑफेंसेस आल्सो आई डू नॉट से लेकिन थोड़ा सा सबमिशन तो सही होना चाहिए ना इम्प्यूट ऑर्डर भी तो घर से पढ़ के आना चाहिए नहीं जब हम पढ़ सकते हैं तो आप तो पढ़ ही सकते हैं heard the learned counsel appealing on behalf of the parties. The learned counsel for the petitioner has submitted that petitioner has been falsely implicated in this case and he is in custody for last 18 months. He has also submitted that a few witnesses have been examined who have not fully supported the prosecution. Counsel for the state has opposed the prayer and has submitted that the murder weapon has been recovered from the possession of the petitioner as is apparent from the impugned order. He submits that trial can be expedited. After hearing the learned counsel for the parties and considering the serious allegation against the petitioner, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure prompt production of witnesses. The counsel for the state is directed to communicate this order to the director of prosecution and also to the superintendent of police to ensure compliance.
Appearance दीजिए.
Item 6, DA.2158 of 2026.
Arms no firearms have been recovered from the person of this prisoner. Only 3 cartridges have been recovered.
Do you have any antecedent?
Yes.
You are one incident.
Two antecedents.
And
इसमें as per usual order number 302 and answer.
इसमें जिसका पॉकेट से रिवॉल्वर और गोली निकला है उसका बेल है बैक कोऑर्डिनेट पे। इन लोग को अरेस्ट किया गया था इसमें।
उनका भी एंटीसीडेंट है।
इसमें तो नहीं लिखा हुआ है। मेरा
एक है कि दो है तो वो दो बोल रही है।
इसमें दो लिखा हुआ है। Yes, and further case number 244 of
हमको एक का मान।
इसमें तो नो क्रिमिनल एंटीसीडेंट की ग्राउंड पे है।
हाँ उसमें लिखा हुआ है लेकिन उनके पास से फायर आर्म्स रिकवर हुआ है मेरे पास से फायर आर्म्स नहीं है ये लिखा हुआ है
कार्ट्रिज फायर आर्म्स के डेफिनेशन से बाहर है।
नहीं है बात लेकिन जिसके पास से रिकवरी हुआ है उसका जेल हो गया है तो
एंटीसीडेंट भी तो नहीं है ना उसका।
एंटीसीडेंट के बारे में तो हम नहीं जानते हैं उसमें जो लिखा हुआ है नॉन एंटीसीडेंट
लिखा हुआ तो गलत तो नहीं लिखा हुआ है ना।
कह सकते हैं लेकिन हमको मालूम है कि मेरा
कहाँ है इनका एंटीसीडेंट?
पेज 4 मैडम।
पेज नंबर
4 running this bottom minor. Paragraph 70 of the case says criminal antecedent against the petitioner. Body case number 94/2025 underscore 302 and 201 of the INC and other case 244 of 25 underscore 309.
इन केसेस में आपको बेल हो गया? इन दोनों केसेस में हो गया? सैंक्शन भी नहीं आया अभी प्रोसिक्यूशन सैंक्शन। That is also pending before the deputy commissioner. कब से है जेल में?
24/9/25
और the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that only 3 live cartridges has been recovered from the possession of the petitioner. He has also submitted that the person from whom country-made pistol along with 2 cartridges were seized has been granted bail by coordinate bench of this court on 11/2/2026 in PA number 11976 of the The petitioner is in custody since 24/9/2025. Counsel for the state has opposed the prayer and has submitted that the petitioner has 2 criminal antecedents. And one includes criminal antecedent under section 27 of the Arms Act. From the appeal order, it appears that prosecution sanction is awaited. After hearing the learned counsel for the parties and considering the fact that one co-accused has been enlarged on bail by coordinate bench, the petitioner is eligible to be enlarged. And considering the custody. Okay.
Item 7, DA.2160 of 2026.
Yes, please. When do you want? At the request of the counsel for the petitioner, pose this case on Monday.
Item 8, DA.2170 of 2026.
They are a land dispute and the dispute arises when a digging soil in a pond.
The allegations are very serious.
General and omnibus allegation.
General and omnibus की बात ही नहीं है. The manner in which the offence has been done is very serious. You are named in that file.
Named in that file, but no general and omnibus allegation also no incriminating article has been included.
इंक्रीमेंटिंग आर्टिकल का जरूरत नहीं है 300-400 का आदमी का भीड़ में. एक आदमी एक थप्पड़ भी मारेगा तो आदमी मर जाएगा.
काउंटर ब्लास्ट केस लॉर्ड
कोई बात नहीं.
काउंटर ब्लास्ट के आपके स्टडी 1.5 महीना लगेगा.
घोषणा करके मस्जिद में घोषणा करके 300-400 की भीड़ इकट्ठी की गई. हाउ सीरियस इट इज. यू सीरियस.
कौन ये किया नहीं कि उसको कोई स्पेसिफिक नहीं है.
कोई
नेचर
कुछ दिन रुक जाइए.
नेचर ऑफ इंजरी
सिंपल इंजरी है. 400 आदमी मिलकर मारे हैं. घेर ले वही बहुत है.
हम लोग को
इंजरी का कोई जरूरत ही नहीं है.
हम लोग को भी चोट लगा.
BA number 2170 of 2026.
डायरी मंगा लिया.
कोई जरूरत नहीं. Heard the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that though the petitioner is named in the FIR, but there is omnibus allegation against all the accused persons. The petitioner is in custody since?
Custody since 3/2/2026.
The petitioner is in custody since 3/2/2026. The learned counsel for the state has opposed the prayer and has submitted that the manner in which the alleged offence has been committed is quite serious, and the petitioner may not be enlarged on bail at this stage. अभी तो चार्जशीट नहीं हुआ होगा. She has submitted that. At this, the counsel for the petitioner has submitted that charge sheet has not yet been submitted against the petitioner. After hearing the learned counsel for the parties and considering the fact that the petitioner is named in the FIR and allegations in the FIR are quite serious, charge sheet has also not been submitted so far. The matter is under investigation. This court is not inclined to enlarge the petitioner on bail at this stage. At this stage, क्या चीज़?
Item 9 DA.21.07 of 2026.
This matter relates to the mobile network. The raid was conducted in public possession and it is alleged that on raid,
Who were you? You were driver or khalasi or who?
I am the owner cum driver of a vehicle bearing registration number JH01DM1776 on which the recovery of 400 kg of beef has been shown by the police. However, my vehicle was empty, Lordship, that the place of occurrence is a pure marketplace and my vehicle was parked there for loading some articles. Now, Lordship, in this case, the police has not complied the mandatory provision of the section 105 of the DNSS, Lordship, which clearly says that if any search or seizure is conducted, then there should be a audio, video, or any other electronic means by which the entire process should be recorded. The shall word has been used, Lordship. But in this case,
when are you in custody?
Lordship, I am 1/11/2025. Charge sheet has been submitted, case has been committed, Lordship.
Or the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that although it is alleged that the petitioner has submitted that the petitioner is owner cum driver of the vehicle, in connection with which it is alleged that 400 kg of objectionable meat has been recovered. He has also submitted that the provision of section 105 BNSS with regard to search and seizure has not been followed, and the petitioner is in custody since 1/11/2025, and he has been falsely implicated in this case. He submits that the vehicle was parked on the spot for the purposes of loading and unloading of other materials, and the vehicle was actually empty. Very up.
Yes.
The learned counsel for the state has opposed the bail for bail and has submitted that there is direct allegation against the petitioner. After hearing the learned counsel for the parties and considering the fact that there is direct allegation against the petitioner, this court is not inclined to enlarge the petitioner on bail.
But suppose this has been granted will just today itself by the honorable
आप
court.
जितना बहस किए हम उतना लिखाए, ऑर्डर के बाद कुछ नया कहानी नहीं सुनाई।
Item 10 DA.18.04 of 2026.
The trial is in advanced stage.
हमारा नाम 164 का स्टेटमेंट में विक्टिम लाया है, वो हमारा नाम मिलेगा, वो किसी कोई अमन आसमान के साथ रह रही है। इसके बाद पुलिस इसको रिकवर की 164 के स्टेट
जो हम बोले आप सुने नहीं, आपका ट्रायल एकदम एडवांस स्टेज।
हाँ, वो 4 विटनेस में से 4 मदर फादर एंड ये ब्रदर ऑफ द विक्टिम एग्जाम दिया। सिमिलरली स्टेट माइनॉरिटी ने अमन के साथ रह रही है।
ठीक है, कोई बात नहीं, आपका ट्रायल एक्सपीडाइट करा
कहीं नाम अगर
कोई बात नहीं, ट्रायल एक्सपीडाइट करा देते हैं ना, थोड़ा वेट करिए। अगर उसके बाद भी ऑर्डर के बाद भी अगर विटनेस नहीं आए तो स्टेट पे तो कंटेम्प्ट होगा और आपको बेल होगा, क्योंकि यहाँ डायरेक्शन है, डायरेक्शन नहीं कंप्लाई करने से तो कंटेम्प्ट ही करेंगे। आप लोग को बता दे रहे हैं स्टेट को, जिसमें ऑर्डर होता है कम्युनिकेट करने का, इंश्योर दैट इट इज प्रॉपर्ली एलिगेशन काफी सीरियस है, पॉक्सो है।
सीरियस एलिगेशन है, केवल 164 के स्टेटमेंट दिखाया है, बेनेक्स वाले 164 के स्टेटमेंट को देख लिया जाएगा। और ये एविडेंस जो फादर मदर ऑफ विक्टिम का दिया है, सो इक्वल ये स्टेटमेंट को देख लिया जाएगा, राइट? इनके इन रिकॉर्ड में 164 का पंजाब में हुआ, पुलिस वहीं छोड़ दी, हम लगा है हम लोग।
कोई बात नहीं, आपका ट्रायल खत्म हो गया। DA number 2184 of 2026. Heard the learned counsels appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner has been falsely implicated in this case, and he is in custody since
8/11/2025.
That's older than that.
since 8/11/2025 in connection with case number कब का है? 2017 का, in connection with Sahibganj Musaffir PS case number 74 of 2017. His anticipatory bail application was earlier rejected by this court in ABA number 4965 of 2018 by order dated 29/8/2018. फिर भी आप 2018 से लेकर 2025 तक गए। The learned counsel for the state has opposed the prayer and has submitted that the petitioner has been an absconder, and the trial is in advanced stage in as much as out of 9 prosecution witnesses, 4 witnesses have already been examined. After hearing the learned counsel for the parties and considering the aforesaid submissions and the serious nature of allegation, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure prompt production of witnesses so that trial itself is taken to a logical end. The Counsel for the State is directed to communicate this order to the Director Prosecution and also to the Superintendent of Police of the concerned district to ensure compliance.
Item 11, DA.18.05 of 2026.
राहुल के पास से रिकवरी है, हमारे पास रिकवरी नहीं है।
Antecedent?
कोई एक्सीडेंट नहीं है।
29.2 ग्राम है, ओवरसी 250 ग्राम।
कन्फेशन में लोग उनका ले रहा है, साइन हमारा करा दे रहे हैं। राहुल का कन्फेशन हो रहा है, उसमें मेरा नाम साइन हमारा नाम लिख रहे हैं।
आपका क्या नाम है? विनोद राम।
विनोद राम।
सर्च हुआ राहुल के घर में।
राहुल का राहुल का किराए के
राहुल के घर में 29.2 ग्राम मिला, राइट? कैश मिला, एंड्रॉइड मोबाइल मिला। अब बाथरूम में छुपे हुए थे।
ठीक है सर, एक का प्रश्न देखा जाए बिल्कुल। ये राहुल के लिख रहा है, साइन हमारा करा रहा है, पुलिस के पूरा चीज करने देखा है, कैसे मैनिपुलेट किया जा रहा है।
आपके पास से कितना रिकवरी?
कुछ नहीं हमारे पास।
रिकवरी नहीं है? इनके पास से कोई रिकवरी नहीं है?
कितना प्रोसेस नहीं है।
यस, हाउस ऑफ राहुल कुमार, इनके पास से अलग से कोई रिकवरी नहीं है ना? तो बाथरूम में छुप गए। एंटीसीडेंट नहीं है ना आपका? एंटीसीडेंट होगा तो रिलीज नहीं होंगे आप, बता दें। Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that it has been alleged that intermediate quantity of brown sugar has been recovered from the possession of the petitioner. However, as per the prosecution case itself, the raid was conducted in the house of Rahul Kumar and he was apprehended with 29.2 grams of brown sugar and petitioner was found in the washroom. The learned counsel submits that the petitioner is innocent and he has been falsely implicated in this case and the petitioner has no criminal antecedents. The counsel for the state has opposed the prayer, but the prosecution story as narrated by the petitioner is not in dispute. After hearing the learned counsel for the petitioner, for the parties, and considering the fact that the raid was conducted in the house of Rahul Kumar and the petitioner was also found there, and it is alleged that intermediate quantity of brown sugar has been recovered and that the petitioner has no criminal antecedent, the petitioner is directed to be enlarged on bail. The conditions will be the learned court is directed to call for a report from the state in connection with criminal antecedent of the petitioner. If any antecedent is found, the petitioner shall not be released on bail.
Grading for admission, item 12, DA 10594 of 2025.
The major rating. There is a 4-month delay of money in the FIR. The allegation is page number 9 not shown of the FIR. That is, she states that the husband of the informant went to earning at night. The petitioner came to his house and committed rape. But she is living with her father-in-law, mother-in-law, and 3 child. But she never raised any alarm and neither reported any incident previously. And because she was selling local liquor and the petitioner objected the same, that's why she falsely implicated the petitioner and the charge sheet has been submitted.
Since when she is in custody? He is in custody.
He is in custody since 6/9/25. And 2 witnesses they examined. In cross examination, they have stated that Abhishek Ju was living in a rented house and the informant
Was living in
a rented house and informant went to Abhishek Ju by leaving her infant child and she was living with her and upon the complaint
No, I couldn't get it. The informant was living in a rented house.
the petitioner was living in rented house. The informant went to live with the petitioner by leaving her infant child.
What do you have to say?
The allegation is of forceful rape against a consent.
Any medical report?
The medical report is not there because the delay has been explained by that the husband is working in
Did she raise, she is a married lady, did she raise any alarm? Because the husband is not there, she will not raise an alarm.
But when he came back, it happens a lot that sometimes the lady is unable to convey on the road.
No, it does not happen in this stage anymore.
It happens a lot.
No. बेल ही तो देना है 6 लाइन से कस्टडी है और कुछ केस डायरी में है
But medical supervisor, the medical report is concerned, it's not corroborated regarding that. But apart from that, he has supported in the 180 and 183 DNS statement. Entirely she has supported it.
कोई डेट बताया है कब किया है
FIR में date तो नहीं आया,
कोई डेट ही नहीं है
लेकिन बार-बार करेक्ट कर रहा है in his absence.
For the learned counsel preparing on behalf of the parties, the learned counsel for the petitioner submits that the petitioner is in custody since 6/9/2025 and it has been alleged by the informant that the petitioner has repeatedly raped her in absence of her husband as her husband had gone to Gujarat to Jammu to earn a living. And when he came back from there, the case was instituted. The learned counsel submits that the petitioner is a married lady and living with her mother-in-law, father-in-law and children, and in the FIR neither any specific date has been mentioned and in the FIR no specific date of the alleged offence has been mentioned and she never raised any alarm and admittedly she never raised any alarm. He has also submitted that in the medical examination also nothing has come to show that there was forceful sexual assault. The learned counsel for the state has opposed the prayer and has submitted that the delay in filing the FIR has been explained. The FIR was filed once the husband returned from Jammu and the victim has supported the case in a statement recorded under section 183 DNS. For the 181 and 180 and 183. Heard the learned counsel's opinion on behalf of the parties. And considering the submissions of the petitioner, and that it is said that the victim was living with her in-laws and children, though her husband was away. And that though her husband was away, and admittedly she never raised any alarm, the petitioner is directed to be enlightened.
Item 13, DA.18.03.2025. of 2025.
Allegation that on the point of demand of how purchase was there and
Within a very short time.
is there, but my lord,
You are the husband?
and the
He died in your house?
why?
Enough.
But for a moment, if the one statement of the Nani may be considered,
नानी का statement अभी नहीं, आपका trial में consider.
because one that is look calm that it is a suicide, but simplicity of suicide. Because it was a love marriage between the party members, marriage was not accepted by the parents of the suicide victim.
So she was killed or it was a suicide?
It is a suicide marriage.
BA number 11088 of 2025. Heard the learned counsel appearing on behalf of the party. The learned counsel for the petitioner has submitted that the petitioner has been falsely implicated in this case. His wife had committed suicide. He has also submitted that there were love marriage between the petitioner and the victim, and it appears that the marriage was not acceptable to the family. The learned counsel for the state has proposed a prayer and has submitted that within a short span of marriage, the victim was found dead in the matrimonial house, and the petitioner is the husband. After hearing the learned counsel for the parties and considering the serious indirect allegation against the petitioner, this court is not inclined to enlarge the petitioner.
Item 14, DA.18.61 of 2025.
Yes, please.
Initially, the FIR was registered for the offense principle and the section 364 and 24 of IPC. And later on, also, the charge sheet is submitted for the offense principle and the section 452, 302 and 201, 120 of IPC also. So, allegations are against the three named accused persons, and there was allegation that one Sonalal Maria was having a land dispute with the deceased, and on that basis, suspicion was raised against the three accused person and FIR was lodged. After completion of investigation, also the charge sheet has already been submitted, and after my instruction, also out of 7 charge sheet witness 2 have been examined. There is no specific allegation against the petitioner's lordship, and only on the basis of suspicion his name is there.
Please read the FIR once.
पूर्वक कहना है कि मेरा नाम बाबूलाल मड़ैया उम्र 54 वर्ष पिता स्वर्गीय बाबूराम मड़ैया ग्राम रमनी जबरदह थाना सुंदर पहाड़ी जिला गोड्डा का रहने वाला हूँ। महाशय मेरी छोटी पुत्री मीना देवी का विवाह ग्राम कैरासोल, थाना सुंदर पहाड़ी, जिला गोड्डा के निवासी अनंत मरिया का बड़ा बेटा सुलाल मरिया के साथ हुआ है। मेरा समधी अनंत मरिया की कुल 5 लड़का लड़की हैं, सभी सूरत में काम करते हैं। मेरी पुत्री मीना देवी भी मेरे दामाद सुलाल मरिया के साथ वहीं रहती है। आज सुबह में मेरी बेटी मीना देवी मुझे फोन करके बोली कि मेरी सासू माँ सावित्री देवी और मेरे ससुर अनंत मरिया का फोन 1 सप्ताह से नहीं लग रहा है और ना ही कोई संपर्क हो पा रहा है। आप कैरासोल गांव जाकर देखिए क्या बात है। उसके बाद में आज दिनांक 26/2/2024 को कैरासोल गांव अपने समधी के घर पहुंचा तथा समधी एवं समधी का खोजबीन किया, परंतु दोनों घर पर नहीं मिले। आसपास के लोगों से पता किया तो स्थानीय ग्रामीणों ने बताया कि वे लोग भी 4-5 दिनों से मेरे समधी को नहीं देखे हैं। ग्रामीणों ने बताया कि हम लोगों को लगा कि मेरे समधी किसी रिश्तेदार के यहाँ गए होंगे। इसके बाद हम स्थानीय ग्रामीणों के साथ अपने समधी के घर गए तो देखे कि उनके घर के दीवार पर खून के छींटे लगा हुआ है। आगे ग्रामीणों द्वारा जब भी बताया गया कि मेरे समधी और समधी का जमीन विवाद सोनाराव के अगेंस्ट में चार्जशीट नहीं फाइल किया।
क्या लिखा? इनकी कन्फेशन पर कहाँ से बोल रहे? कहाँ से बोल रहे? यू हैव द केस डायरी? आपकी कन्फेशन पे रिकवरी है, उनको दिखाइए। इम्प्यूट ऑर्डर में कहीं नहीं देखा इसलिए पैरा 12 ऑर्डर
9 में कंफ्यूजन है और 30 में रिकवरी
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody and trial is going on, and out of 7 charged witnesses, 2 have been examined. He submits that the petitioner has been falsely implicated only on account of suspicion, and as per the FIR, the suspicion has been raised on the point that, or on the ground that there was land dispute between the parties. The petitioner is in custody since 27/2/2020. The learned counsel for the state has opposed the prayer and has submitted that, and has referred to the case diary to submit that on the confession of the petitioner, the dead body has been recovered. Half-burned dead body. Yes. Half-burned dead body has been recovered. After hearing the learned counsel for the parties and considering their aforesaid submission based on case diary, and the trial is in progress, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure prompt production of witnesses. Counsel for the state is directed to communicate this order to the Director of Prosecution and the Superintendent of Police of the concerned district.
Item 15 DA.18.09.06 of 2025.
आर्म के केस में हमारे पास रिकवरी नहीं है, जिनके पास रिकवरी में अपने लोग का
आपके पास से क्या चीज का रिकवरी?
हाँ, कुछ रिकवरी नहीं है मेरे पास। हम ये कंप्लेशन से अरेस्ट हुए कस्टडी में 23/3/2025 से 1 ईयर इन कस्टडी में कोई रिकवरी। एंटीसीडेंट होने के पैराग्राफ 508 में मैं दूसरी 2 में अरेस्ट हुआ, इसके बाद इसके को रिमांड किया गया। आई मिस्टेकली पैराग्राफ
और उससे पहले का कोई केस नहीं?
उसके वजह से ये इसी को अरेस्ट। हमारे पास रिकवरी नहीं है, लोग को इसलिए रिजेक्ट किया गया कि इसका रिजेक्ट है इसके साथ।
केस तो 2023 का है।
हाँ तो देश में
2023 से अब तक क्या हो रहा था? Where were you from 2023? Yes. 2023 से अब तक क्या हो रहा था?
हमारे बिहार में नहीं था, पुलिस हमको पकड़ नहीं रही तो घर पर
क्या बोलना है आपको? इनसे कोई रिकवरी है?
उसका नंबर ऑफ बैंक ऑर्गेनाइजेशन
इसका क्या प्रूफ है? बैंड ऑर्गेनाइजेशन का मेंबर है, पेपर में छपता है। एंटीसीडेंट से ही ना पता चलेगा प्राइवेटली। आपका एफआईआर में नाम नहीं है, भागने वालों में आपका नाम नहीं है।
भागने वाला में वो उनका कन्फेशन की तरह नाम है कि वो अरेस्ट करा अंदर या तो वो बदली पल्ला पर आदमी थे जो भाग देश की 25 से वो बुलंद गए कस्टडी में रहने को कभी भी नहीं यूपी में भी कोई
और गलत काउंसिल से पेड ऑन बिहाफ ऑफ द पार्टीज। The learned counsel for the petitioner has submitted that the name of the petitioner has come in the confession statement of co-accused, and at the time of apprehending the co-accused, it is alleged that the petitioner had run away from the place of offence. He has also submitted that there has been no recovery from the possession of the petitioner, and the petitioner is in custody since 23/3/25. He has submitted that the petitioner was arrested on 17/1/25 in connection with Matrimonial PS case number 2 of 2025, and from the said case he has been remanded in the present case. It was instituted in the year 2023. इसमें बेल मिला?
इसमें उसमें नहीं
The learned counsel for the state has opposed the prayer and has submitted that the petitioner is a member of banned organization PLFI. However, it does not dispute that there has been no recovery from the petitioner and his name has transpired in the confession statement of co-accused. After hearing the learned counsel for the parties and considering the aforesaid submission and the custody of the petitioner since 27/3/2025, the petitioner is admitted to be enlarged on bail. और कोई केस नहीं है ना आपका?
हमारा नहीं
और कोई केस नहीं है इसके अलावा? 2 केस के अलावा तीसरा केस नहीं है ना?
ये जानकारी नहीं है यूपी में रहा है इसी से लेकर के बाकी जो पता है सब आपके में।
Item 16 DA.18.07 of 2026.
Yes, sir, you have to understand the two of the mail given. Earlier, price, the bail of this petitioner has been rejected. What is the result of this?
2 ही एग्जामिन होना है।
Proceed. Out of 8, 6 witnesses have been examined. Prosecution have been
नहीं ट्रायल नहीं करेंगे, बाकी दोनों विटनेस को एग्जामिन करा।
नॉट हम नहीं बोल रहे। कल लास्ट ऑर्डर देख लिया जाए 30/1/2026 का, उसमें स्टेटस रिपोर्ट मंगवाया गया था। 18/7/2025 को ये यहाँ से रिजेक्ट हुआ लॉर्डशिप। लास्ट 1 ईयर एक भी विटनेस एग्जामिन नहीं हुए। 18 लॉर्डशिप 30/1/2026 ऑर्डर देखिए।
कब हुआ था लास्ट विटनेस एग्जामिन?
Last witness has been examined. बाईस 3/2025. I in this entire
अब करेंगे एग्जाम।
मांगा गया था।
नेक्स्ट डेट बताइए ना कौन सा, उसी दिन को विटनेस प्रोडक्शन का ऑर्डर करते हैं, बताइए अगला तारीख कौन सा है? सब तो ऑफिशियल विटनेस बचे होंगे, अब तो ऑफिशियल विटनेस ही बचे होंगे ना, कौन बचा है?
डॉक्टर आयु और ये डॉक्टर बच्चे
बस इनका तो ये तो हमारे
ऑर्डर होने के बाद भी एक साल
आप प्रोड्यूस करेंगे ना विटनेस?
डॉक्टर खाली देख लीजिए डॉक्टर, हम ऑर्डर शीट पे लगाए हुए हैं।
अब नहीं, अब प्रोड्यूस करेंगे। आप बताइए ना नेक्स्ट डेट कौन सा है, बता दीजिए नेक्स्ट डेट।
और जो 6
बताइए नेक्स्ट डेट बताइए ना, उस दिन कौन किसको एग्जामिन करिएगा बताइए, डॉक्टर
दोनों
को?
बुला लिए थे, दोनों के सामने करते हैं।
अगला तारीख बताइए कौन सा?
अप्रैल
10 अप्रैल को ना। और इसमें दिए ही है रिपोर्ट में कि एंड ऑफ अप्रैल में ट्रायल आपका कंक्लूड हो जाएगा, रिपोर्ट में ही दिए।
लेकिन
और चलो
नोटिस में ऑर्डर होने के बाद नोटिस 7 डेट पास हो गया, लेकिन कोई विटनेस नहीं आया।
अब आएंगे
भाई
मार्च से अप्रैल पहुंचने में कितना टाइम लगेगा? आधा मार्च में। और the learned counsel is heard the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that out of 8 witnesses, 6 witnesses have been examined, but the last witness was examined on 22/3/2025. He has submitted that for a gap of for a period of about 8 months, no witness was examined.
1 year हो गया, 22/3/2025 से मार्च चल रहा है।
He submits that the next date in the trial is on 10/4/2026. A report has been, counsel for the state has opposed the prayer and has submitted that the state would ensure prompt production of witnesses. The remaining witnesses are official witnesses. A report has been received from the concerned court giving the tentative time to conclude the trial by end of April 2026. After hearing the learned counsel for the parties and considering the fact that the bail application of the petition has been rejected multiple times by this court. कई बार हुआ ना, multiple times before this by this court, and the serious and specific allegation against the petitioner, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure prompt production of witnesses, and the next date, as stated by the petitioner, is on 10/4/2026. The learned counsel for the state is directed to communicate this order to the Director of Prosecution and also to the Superintendent of Police of the concerned district to ensure compliance. Communicate. 10 तारीख को विटनेस आ जाना चाहिए।
लिबर्टी से दिया जाएगा, नहीं आपने
आपको लिबर्टी, आप रोज बेल फाइल कर सकते हैं।
डॉक्टर 1 साल पहले में हमको लिबर्टी दिया गया था, किस पे डेट किया जाएगा डॉक्टर? 1 साल हो गया, अभी एक भी विटनेस
अगर विटनेस नहीं आते हैं, आप एक सेकेंड, अगर विटनेस नहीं आते हैं, ठीक है, एंड दे हैव नो प्लॉजिबल एक्सप्लेनेशन, राइट, आपको बेल और इनको कंटेक्ट तय। एसपी को तो यही बुलाएंगे हम, बिकॉज देयर इज अ डायरेक्शन टू प्रोड्यूस विटनेसेस, दे कैन नॉट एस्केप फ्रॉम दिस। दो विटनेस ऑफिशियल विटनेस प्रोड्यूस नहीं कर सकते हैं तो किसी को जेल में थोड़ी रखेंगे।
Lord, we examine here out of 6 not
अगर सजा हो जाएगा तो कितना साल सजा होगा?
Lord होगा तो लाइफ टाइम होगा या ऊपर
इसीलिए थोड़ा वेट करें।
लॉर्ड लेकिन सपोर्ट नहीं किया, इन्फॉर्मेट सपोर्ट नहीं है, इन्फॉर्मेट PW3 है लॉर्ड आउट ऑफ 6 जो विटनेस सेक्टर किसी ने मेरा नाम तक नहीं लिया लॉर्ड।
थोड़ा सा वेट करें।
हम लॉर्ड साहब का रिपोजिशन लगाए हुए हैं, किसी ने मेरा नाम तक नहीं लिया है।
आइटम 17 ये 534/2026
Lordship, senior has been related to doctor. He has been suffering from back pain.
From?
Ma'am, I am
He is suffering from?
back pain.
Who is your senior?
So please,
A counter affidavit has been filed in this case during the court proceedings, which is taken on record. Counsel for the petitioner seeks adjournment by submitting that his senior, Mr. Rupesh Kumar, who has to argue this case, is not attending the court proceedings as he is not well. कहीं नहीं आ रहे ना? ऐसा तो नहीं सिर्फ इसी कोर्ट के लिए बीमार हो गए। बताइए कब करना है?
ma'am, after 1 week,
Holds this case on आज कौन सी तारीख है? Wednesday. Next Wednesday.
much of that life.
Item 18 ये 886/2026
The fire was initially lodged under section 109, later on converted to 103. In addition, before going to the fire, I would like to point out page 23 for the kind consideration. The informant has deposed witnesses in para 12. He has specifically mentioned that he has not given any written report before the police concern. And he even in the FIR he claims to be an eyewitness, but in the deposition he says that I have not seen anything. And the sister of the deceased also examined as PW1. She has also stated, she has also not supported the case. Whereas the para 14 of the PW1 at page 21 is very relevant. That she is categorically mentioned that her signature was put in the FIR on the instance of the police. Page 21, para 14.
In the FIR, the signature of the informant is present.
This is present.
Is the name, the FIR of the signature of this lady is also
Also
present.
present.
Does she say that he was not there?
Yes, they were saying in the
Does she say that this informant was not there?
Yes.
Where is that statement?
Page number 22, para 3.
ये तो 22 तो उसका हो गया ना informant का।
Informant का.
ये जो साथ में जो है,
हाँ.
does she say that informant was also not there?
हाँ, para 2 में. para 2 में. Page 19.
पढ़ी?
हम लोग खाना खा के खाना खाए, बाहर खाना खाने के बाद रूम में सोने चली गई। मैं कपड़ा अलग रूम में आयरन कर रही थी। बाहर पटाखे बजने की आवाज आई तो मेरे होने वाली जेठ सास नीलम तुरंत बाहर निकली। मैं भी उसके पीछे निकलकर वॉशरूम गई। जब घर वापस गई तो सुने कि बहन को कोई गोली मार दिया। मैं सुनकर बेहोश हो गई।
आपसे क्या सवाल पूछ रहे हैं, आप क्या जवाब?
In the FIR they are saying that they were.
आप बोल रहे हैं कि इंफॉर्मेंट ने FIR दर्ज ही नहीं किया।
हाँ, उन्होंने बोला।
इन्होंने तो बोला है कि इन्होंने किया।
नहीं, he has turned hostile.
Yes, turn hostile. वही सिग्नेचर है उनका। ऐसे सपना तो नहीं आता ना पुलिस को।
जो पैरा 13 देखा जाएगा उसमें
आदमी मरा है कि वो भी हॉस्टाइल है, वो भी जीवित है।
उन्होंने बोला क्या लिखा तो कुछ नहीं पता। I am not.
कितने विटनेसेस हैं? How many witnesses are there?
Total there are 8 witnesses, 400 witnesses.
कितने एग्जामिन हैं?
2. They came to their eyewitness in their trial, and both the eyewitnesses have been examined.
Counsel for the state is directed to file a counter affidavit called for case diary from the concerned court, and also the present status of the case. The status report should indicate as to how much time the court is likely to take to conclude the trial. Communicate post on 9th.
Item 19, DA.18.07 of 2026.
2 weeks time.
किसकी आपको टाइम चाहिए?
तो ये सीनियर ऑर्डर उस स्टेशन में है
2 हफ्ता कोर्ट नहीं आएंगे? ऐसा कौन वकील होता है 2 हफ्ता कोर्ट नहीं है? हाँ, आपकी सीनियर 2 हफ्ता कोर्ट नहीं आएंगे? हम नहीं मानते, मानने वाली बात नहीं है। कौन है आपके सीनियर?
अमित कुमार।
अमित कुमार तो बहुत सीरियस प्रैक्टिशनर है।
नहीं, बहुत सारे अमित कुमार हैं।
बहुत सारा। आप सोच लीजिए, अगर उनका हमें क्लियरेंस कहीं और देख लिए ना तो आप ही से पूछेंगे। 2 हफ्ता तक कोर्ट नहीं आएंगे वो। शादी है उनकी?
शादी नहीं है, लेकिन वो आपको स्टेशन में रीजन हमें नहीं पता।
नाम बताइए। नाम?
नेहा कुमारी।
MS Neha Kumari submits that the arguing counsel, Mr. Amit Kumar, is not attending court on account of personal reasons and prays for 2 weeks. State कौन है इसमें? Who's for the state? Nobody appears on behalf of the state. Are you there? आप हैं? Counsel for the state is present. The state is directed to file a counter affidavit that the case diary be called for from the concerned court. Post this case on 9th of April. उसे टाइम मत मांगिएगा, एक बार एजेंट करने के बाद हम दोबारा एजेंट नहीं करते, ठीक?
Item 20, DA.1010 of 2026.
Has given threatening to the informant that he will kill to the informant. Thereafter, the unknown person has come by the bike and they have opened the fire door. Subsequently, the name of the petitioner has come on the basis of confessional statement of the Ziaul Ansari law, and since Ziaul Ansari has enlarged on bail, not that it has page number 2, page number 20, not the next chapter. The other co-equivalent, that is whoever that whose bail has already been rejected with the same EP model law, he has also enlarged on bail law. In the EP model, it is stated in law, on behest of this petitioner, arms were recovered. Petitioners know on the behest of the accused petitioners in law. There are 2 petitioners before the learned and district and session there now.
What do you say?
State confession से arms recovered है. आप 3 criminal acts
नहीं, कहाँ से बोल रहे थे? बताइए कहाँ से बोल रहे हैं? कहाँ से बोल रहे हैं क्रिमिनलाइज में?
इसका नहीं है ये और से
इनका तो कोई एंटीसीडेंट नहीं है। इनके अगेंस्ट में क्या है?
इनके कंप्रेशन से रिकवर है।
होता है कि आर्म्स रिकवर
अरे आर्म्स रिकवर है, इसी आर्म्स से मारे हैं क्या?
नहीं ऐसा कहीं नहीं।
उसका हुआ है फॉरेंसिक एग्जामिनेशन कि इसी आर्म्स से मारे, पता चल जाता है ना फॉरेंसिक में। तो ऐसा आ गया है रिपोर्ट?
नहीं
कब से कस्टडी में?
स्टडी में 14/1/2014
चार्जशीट वगैरह हो चुका होगा ना?
शासित हो जाना चाहिए।
Heard the learned counsels appearing on behalf of the parties. The learned counsel for the petition submits that the name of the petition has come in the confession statement of co-accused, and the petitioner has been falsely implicated in this case. We have also submitted that the petitioner is in custody since 14/11/2025, and a number of co-accused persons, खाली एक ही का है,
2 का जो रिकॉर्ड ऑर्डर दिया, एक का लगाया है सेक्शन 2 पेज नंबर 20। जियाओ जिसे कंफ्यूजन का है उसका भी
submits that the person who has confessed the guilt, namely Jiaul Abdullah alias Jiaul Sheikh, has been enlarged on bail in BA number 11311 of 2025 by order dated 8/12/2025, and another co-accused, namely Sohaib Akhtar alias Lulu, has been enlarged on bail in BA number 829 of 2026 by order dated 26/2/2026. The learned counsel submits that a criminal antecedent report was called for, and as per the report, the petitioner has no other criminal case. The learned counsel for the state has opposed the prayer and has submitted that on the confession statement of the petitioner, the arms has been recovered. After hearing the learned counsel for the parties and considering the fact that the name of the petitioner has come in the confession statement of co-accused, and other co-accused having been enlarged on bail, this court is inclined to enlarge the petitioner on bail.
Item 21, DA 1792 of 2026.
कोई केस में केस डायरेक्ट मैंने सेंड रिपोर्ट कॉल पर हुआ है। साइबर क्राइम का केस है, मेरे ऊपर एलिगेशन यही है कि ऑन सीक्रेट इन्फॉर्मेशन पुलिस से जब
कौन से कोर्ट से हुआ है? कब है डेट?
डेट को इवन 13/3 को ऑर्डर हुआ है। वो
डेट बिना डेट के इस कोर्ट में कोई ऑर्डर नहीं होता।
40 अप्रैल हुआ शायद, ऑर्डर नहीं है मेरे पास।
8/4 को डेट है ना? Counsel for the petitioner has submitted that, arising out of the same FIR in the case of another co-accused, the case diary and criminal antecedent report has been called for. BA number 1855 of 2026, and the next date fixed in the case is 8/4/2026. The state is directed to file a counter affidavit in this case, along with the criminal antecedent report of the petitioner. Let this case be tagged with DA number 1855 of 2026 and be posted on 8/4/2026.
From the supplementary list, under heading for orders, item 3, FA 92 of 2022.
Proceeding 26 let's see. IE number 6051 2025. In this case, the appellant number 10 Dorsey, that Dorsey, whose legal years are stated in para 3 Dorsey. And the wakalatnama of the proposed legal years has already been filed. I restricted para 6 of my IE.
IA number 3416 of 2025 in AP number 92 of 2022. Heard the learned counsel appearing on behalf of the appellant. आप respondent हैं? And the respondent state. It has been asserted that appellant number 10 has expired on 14/1/2025. The names of legal heirs and successors has been mentioned in paragraph 4 of the interlocutory application.
3, sorry.
4 में है ना, एक चौथा भी है। अर्चना भूल।
दोनों में
अच्छा। The wakalatnama has been filed along with the interlocutory application and the death certificate has also been placed on record. He submits that the case was admitted by this court on 24/4/2023. Counsel for the state has no objection so far as the for substitution is concerned. After hearing the learned counsel for the parties and upon going through the interlocutory application, the prayer for substitution is hereby allowed. Counsel for the appellant is directed to delete the name of the appellant number 10 from the first title and insert the name of his legal heirs and successors in writing during the course. Or date?
In this case also the previous person is given no objection. Within 2 weeks also I will file the wakalatnama.
बाकी सब कंप्लीट है सर?
हाँ बाकी complete.
Additional evidence आपने फाइल किया?
There is judgment of the Omnibus Supreme Court that so far as additional evidence is concerned, it will be considered at the time of hearing.
आप रिस्पॉन्स तो फाइल कर लीजिए अगर आपको रिस्पॉन्स फाइल करना है। IA number 2686 of 24 has been filed seeking to adduce additional evidence. The counsel for the state commits that we shall file a response to the interlocutory application within 2 weeks. Within 2 weeks. At this, counsel for the appellant has submitted that the additional evidence is required to be considered at the time of final hearing of this case.
2022 8 SSC page 148. Number divine.
Accordingly, the case is directed to be posted under the heading for hearing on 4th of May 2026. The interlocutory application seeking additional evidence will be considered at the time of final hearing.
3 weeks time.
कोई बात नहीं 3 weeks, लेकिन आप कर दीजिए ना, क्योंकि जब टेकअप होगा तब बोलिएगा फिर से टाइम चाहिए। 3 weeks, ना 3 weeks.
Item 4, FA 226 of 2023.
Yes.
Notice have been served upon the respondents.
I will serve.
I am appealing on behalf of respondent 1 and 2. Other respondents Mr. Appeal. That's a fresh notice.
What is this served through her? Tia.
Oh, Bhatija.
Bhatija. Accept कर ले notice. Family members. क्या है पार्टीशन सूट है?
जी.
1 and 2 और बाकी सब एक ही फैमिली के हैं.
अलग
1 and 2 are the plaintiffs. ये तो बाकी प्रोफॉर्मा है.
3 to 6 are the legal heirs of this one. Manji is there.
Heard the learned counsel is appealing on behalf of the parties. The learned counsel for the appellant has submitted that the notice has been, as per office note, the notice has been received by the concerned respondents or their close family members. He submits that the notice be accepted as validly served. Respondent number 1 and 2 have already appeared by filing wakalatnama, who are the contesting respondents in this case. Considering, आपको कोई objection है इसमें?
नहीं.
The learned counsel for the respondent number 1 and 2 has no objection. The notice is accepted as validly served. Considering the submissions, the notice upon the respondents is accepted as validly served. कब करना है? कब करना है? Pose this case under the heading for hearing on 4th of May.
From the daily list under reading for orders, item 26, FA 37 of 2023.
There is a litigation petition bearing IA number 4796. There is a delay of 524 days in filing the present appeal. The reason behind it that initially the appeal was filed before the Judicial Commissioner, taking into account that the suit valuation is 50,000. Thereafter, the staff reporter made a reporting that no, suit
Notice has been
valuation is
issued on
50,000.
the limitation. Notice
And
has been
thereafter,
issued. Notice has been issued on the limitation.
yes, all have appeared in court.
Any counter filed?
Nothing like that, because it is a factual matrix that we tested the said order up to this honorable court in CMP number. And then this honorable court also declined to rectify the suit valuation. And then after we prayed for withdrawal of the appeal.
आपका substitution allow हो गया है 9 का?
Yes. Everything is okay. This is the
Everything
last
is done. Substitution has been allowed. पता ही नहीं है आपको तो क्या बोलूं। Respondent number 9 का substitution allowed हुआ है।
incorporated 30th July 25 August. The last paragraph, it is made clear that this petition has been allowed only for the purpose of this first appeal and not for any other purposes.
IA number 4796 of 2022. This petition has been filed for condemnation of delay of. How much is the delay? कहाँ लिखें?
Petition is behind.
लिखे कहाँ है कितना दिन का
File
delay?
an appeal before the Jharkhand judiciary.
Where have you mentioned how much is the delay?
Perhaps
524.
Sorry?
The copy which has been served, it has been mentioned in
4796.
How much is the delay?
524.
5? Any objection for condemnation of delay? They have said that they had moved before the judicial commissioner and that they
Because
had-
there is some confusion with regard to the suit right.
That's right.
In the plaint, something else is mentioned, the duty something else is mentioned.
That's
But they took steps for correction of that suit value, and that was rejected.
So ultimately the appeal has been filed over here. So there are some explanation. It has any objection to this? Heard the learned counsels appearing on behalf of the petitioner or on behalf of the parties listening to the
I'm just appealing,
petition.
you are only appealing for respondent.
Respondent number? Appellant and the respondent number 2. Other respondents have not entered appearance in spite of service of notice. बाकी सबको नोटिस हो गया है? बाकी सबको नोटिस हुआ है कि नहीं?
नोटिस हुआ था, सर्विस हुआ है कि नहीं हुआ?
आपको कुछ पता नहीं रहता रिकॉर्ड में, वो सवाल पूछते कुछ पता ही नहीं है। सुनने में बाकी लोगों को नोटिस हुआ है कि नहीं हुआ है? कौन सा ऑर्डर से हुआ है?
ये 21 से 25 को है 1 to 5 and 10 valid.
वो तो हो गया वैलिड 6, 7 and 8
6, 7 returned unserved to police station. आपने ऑर्डर किया,
ठीक है फिर
इसके बाद पुलिस स्टेशन से सर्व हो गया.
नहीं सर has been returned served has been served
No SR received.
yes आपने इनका सब्स्टिट्यूटेड सर्विस के लिए फाइल किया था, वो आपने डिसमिस एज नॉट प्रेस्ड करा दिया. yes 6, 7 and 8 का सब्स्टिट्यूटेड सर्विस के लिए आपने फाइल किया था.
इसमें भी 5 to 25 का ऑर्डर शीट है. 6, 7, 8 returned unserved.
हम नहीं सकते. 9th April 25 को सब्स्टिट्यूटेड सर्विस ऑफ नोटिस 6, 7, 8
ये पुलिस के थ्रू सर्विस कराया गया था और पुलिस के अध्यक्ष के लिए.
In spite of service of notice, the other respondents are not appearing. The counsel for the appellant has pressed IA number 4796 of 2023, and counsel for respond number 2 is present. We have submitted that initially the appeal was filed before the Judicial Commissioner Ranchi, and ultimately when it was filed and the same remained pending, and it was found that the appeal was not maintainable before the state authority on account of pecuniary jurisdiction, and thereafter the present appeal has been filed. Counsel for the respond number 2, though has opposed the prayer for condemnation of delay, but therefore said facts as narrated in the petition seeking condemnation of delay has not been disputed. No counter affidavit as such has been filed to the petition seeking condemnation of delay. After hearing the learned counsel for the parties and being satisfied with the cause shown, IA number 4796 of 2023 seeking condemnation of delay is hereby allowed. अब क्या करना है? It has not been admitted so far. Now fresh notice will go on the parties.
Usually तो admit होने के बाद जाता है, form अलग हो जाता है, form 4 या
admit. Respondent number 2 has already appeared, so no notice need be issued. So far as other respondents are concerned, the respondent number 11 will be represented by the Office of Learned Advocate General. कोई है state का counsel? Did you accept notice? Mr. नाम बताइए. Mr. Manoj Kumar accepts notice on behalf of respondent number 11. Let notice be issued to the respondent number 1, 3 to 10. To the concerned police station, for which requisites be filed within a period of 2 weeks from today. Call for records from the concerned court. Post on 14th. 14th. The Council for the State is directed to ensure that the service report is duly filed by the officer in charge of the concerned police station.
Item 27, FA 216 of 2023.
How many days?
216.
One 276 IA number.
Yes.
1276.
And what is 1277?
Lord, that I am not that was for the purpose not that request has been pointed out by
Okay, that is not surviving anymore. Okay. So how much is the delay?
216.
Yes.
Yes, we filed a reply of earlier receipt. Only we taken the ground for the no proper explanation of the delay.
The appellant is remaining outside. He is posted as Inspector BSF. He may not be available. isn't it? बताइए, अपना ड्यूटी छोड़ के अपील फाइल करने आने में दिक्कत है ना? He is
Senior
forced to
manager,
do- yes.
transmission.
Yes. So therefore,
Zero, 5%.
sorry, what are you saying? देखिए, IA number 1276 of 2025. Heard the learned counsel appearing on behalf of the parties. The counsel for the appellant submits that the first appeal has been filed, the petition has been filed for delay, condonation of delay of 216 days. He submits that the appellants reside outside the state of Jharkhand, which has significantly contributed in delay in filing the appeal, and appellant number 2 is posted as an inspector in BSF and residing in Rajasthan. Further details of the appellants have been mentioned in paragraph 6 of the interlocutory application. The counsel for the state has opposed the prayer and has referred to the counter affidavit.
Appear on behalf of the respondent number 4 and 5. Jharkhand District Legal.
You are for?
4 and 5.
The learned counsel appearing on behalf of
4 and
respondent number 4 and 5 has opposed the prayer and referred to the counter affidavit by stating that the delay has not been fully explained. After hearing the learned counsel for the parties and being satisfied with the cause shown, the delay in filing the appeal is continued. आइए कोई नोटिस नहीं हुआ?
Lord, again, notice was issued on 2/45/25. Notice filed corresponding to 4 and 5.
अब कुछ बचा है इसमें?
इसमें Lord, admit में आया अभी 10,000. And the notice to state of the state in order.
Admit the respondents are the state of Jharkhand. Respondent number 1 to 3 are the state of Jharkhand and their authorities. The counsel for the state accepts notice on behalf of respondent number 1 to 3. Respondent number 4 and 5 is represented through his counsel. So no notice need be issued to the respondents. Call for the records from the
Post
concerned.
title और सीट नाम स्टेट झारखंड स्टेट बिजली वितरण निगम लिमिटेड.
वो आपको करना पड़ेगा, आइए फाइल करके पोस्ट ऑन 4th of May.
Item 28, FIR 257 of 2023.
Yes,
Notice refused.
refused.
Yes. On the last occasion, there was a direction to serve notice. The file the notice to be filed.
The counsel for the appellant submits that, as per the office note, respondent number 1 has refused to accept the notice, and so far as respondent number 2 and 3 are concerned, they have been served either personally or through their close relative. Submits that the notice be accepted as validly served. Considering the submissions and service report, the notice upon the respondents is accepted as valid. और बताइए, ये तो एडमिट केस है.
My prayer is that if adjournment needs to be filed, we will be prepared to this case. Next, we
कोई एपीयर नहीं हुआ है?
No one has printed as per the status.
ट्रायल कोर्ट में भी कोई एपीयर नहीं हुआ है. It was contested or ex parte? In the trial court, it was contested or ex parte? Ex पक्ष में. कब करना है बताइए?
After 1 week.
Counsel for the applicant has submitted that the matter was decided ex parte by the learned trial court, and in spite of, and in the appeal also nobody is appealing. Submits that the matter be posted for final disposal. For final disposal after a week. Post this case for final disposal on 8th of April.
Item 29, Chapter 264 of 2023.
Yes. Nobody appears on behalf of the appellant. However, from the record it appears that there is that the petition has been filed seeking condemnation of delay of 29 days in filing this appeal. The matter arises out of land acquisition proceedings. Counsel, any objection? Counsel for the state has no serious objection so far as prayer for condemnation of delay is concerned. Having gone through the interrogatory application and being satisfied with the caution, the prayer for condemnation of delay through IA number 7818 of 2025 is hereby allowed. Let me call for records from the concerned court. Since the counsel for the appellant is absent, let a copy of this order be communicated to the counsel for the appellant, soft copy, post on 4th of April. प्राइवेट पार्टी तो नहीं है इसमें? प्राइवेट पार्टी तो नहीं है?
Item 30, FA 9 of 2024.
Earlier the notices were issued to all the respondents. Respondent number 134 appeared. Respondent number 134 and 5. 2A personally served. 2B and 2C through brother. Respondent number 6 through his wife. Respondent number 7 through his sister. Respondent number 8 and 9 have issued notices of this. And respondent number 11 to 14 and 17 received personally. Respondent number 15, 16 out of station. Respondent 18, 19 through his son. Therefore, my submission is that the notices served for them will be accepted. And on behalf of respondent number 1, 3 and 1, 3, 4 and 5 and appear.
You are for 1,
3 to 5.
3 to 5. Counsel for the appellant is present. The counsel for respondent number 1, 3 to 5 is also present. The counsel for the appellant has submitted that notice upon respondent number proposed legal years of respondent number 2. They have been substituted. Substitution हो गया उनका?
Yes, ma'am. With regard to respondent number 2, substitution already made, order was passed.
When?
On 15/1/2025. And notice is also issued.
15/1/25, just a moment.
Order number 18. I'm sorry, order number 6.
It is, notice was issued that substitution has not been allowed by this order.
Yes.
Where have I allowed the substitution? I don't allow substitution without issuing notice. Yes. I never do it because there can be more legal years. There can be n number of objections. The date may be different.
He has been also submitted that the person seeking suspension has been filed within time and the detail of the legal years of the suspension.
Yes. Allow कहाँ की है?
But notices were issued by the order.
The learned counsel for the appellant has submitted that notice was issued by the order dated 15 January 2025 on the proposed legal years and successors of respondent number 2. And as per office note, respondent number 2, the proposed legal years and successors have been served either personally or through their close relative. He submits that the notice be accepted as validly served and petition seeking substitution be allowed. The learned counsel for the after hearing considering the office note, the notice upon proposed legal years and successors of respondent number 2 is accepted as valid. The prayer for substitution has been made within time through the IA number 11614 of 2024. Accordingly, the said IA is hereby allowed. The learned counsel for the appellant is directed to delete the name of respondent number 2 from the cause title and insert the name of his legal years and successors as mentioned in paragraph 5 of the interlocutory application. So, the learned counsel has further submitted that respondent numbers 6, 7, 11 to 14 and 17, 18 and 19 have been served either upon themselves or through their close relatives. He submits that the notice be accepted as validly served. Considering the aforesaid submissions, the notice upon the aforesaid respondents is accepted as valid. The office note reveals that the service report of respondent number 8 and 9 has not been received, and respondent number 15 and 16 were shown out of station. आपका इसमें जो है ना रेस्पोंडेंट नंबर सब चेंज किया हुआ है. अब किसको सर्व हुआ है किसको सर्व नहीं हुआ है इज वेरी डिफिकल्ट टू फाइंड आउट. Counsel for the appellant is directed to take fresh steps for service of notice upon the aforesaid respondents through speed post, for which requisites be filed within a period of 1 week.
IA is also there.
IA for?
IA 733 of 2025.
ये एडमिट हुआ है कि नहीं हुआ? एडमिट तो हुआ, अभी तक एडमिट नहीं हुआ. आईए पे नोटिस हो रहा था.
IA is with regard to the service report, respondent number 10 is reporting there that he died.
आईए नंबर?
IA number 733 of 2025.
It is for what? Respondent number 10 has expired.
Yes.
So this is for
For
substitution.
the petition of the name of respondent number 10, because she died during the pregnancy of the suit and it had not been informed by the respondent defendant there. Therefore, his name has not been deleted in the decree.
But then of the degree will be null and void also.
ऐसे नहीं हम आपका डिलीट कर
But
सकते.
right to sue survive because the
आप इसको रिस्पॉन्स फाइल कर दीजिए. Admitted कैसे? IA number 733 of 2025. The counsel for the respondent number 1,325. Trace for time to file a reply to the interlocutory application.
That is also to the appeal to
another point.
The counsel for the appellant is directed to serve a copy of the interlocutory application to the learned counsel by tomorrow. आपका ऐसे पिटीशन नहीं अलाउ हो सकता है सर, सीपीसी के अनुसार चलना पड़ेगा. पोस्ट ऑन 28.
28.
Item 31, FA 13 of 2024.
Last day and notice evidence to be given there for case number 8, 9,
8 and 15.
8, 9 and
9 तो नहीं दिख रहा. Eight, 9 and 15. किसको किसको सर्व हो गया? Counsel for the appellant seeks adjournment by submitting that he has not gone through the office time. Post next week. Next week.
Item 32, FA 198 of 2024.
Notices were issued in the matter of litigation. Respondent number 1 to 4 have appeared for the Falaknama. IA number 9308 of 2024 filed for condemnation of delay of 389.
How many respondents are there?
5 respondents are there.
What about the fifth one?
The state.
State.
Yes.
Okay. Where is your idea? How many days delay?
389 days. 9308 of 2024.
How many days delay?
389 days. The reason for the delay, initially we filed the appeal before the learned district judge. The appeal was later transferred to the district judge 10th Khandwa. Then, after the order,
IA number 9308 of 2024. The learned counsel for the appellant has submitted that there is delay of 389 days in filing this appeal. He submits that initially the appeal was filed before the district judge, but considering the change, but the same was not maintainable, and on account of pecuniary jurisdiction, and thereafter the present appeal has been filed. He submits that notice was issued upon the respondent number 1 to 4 who have already appeared.
through
by filing wakalatnama. Respondent number 5 is the Deputy Commissioner of the concerned district. Considering the amendments made in the interrogatory application, the prayer for condemnation of delay is hereby allowed. Admit no notice need be issued as respondent number 1 to 4 has already appeared by filing wakalatnama, and respondent number 5 is to be represented by the Office of Learned Advocate General. Call for records from the concerned court. Since nobody is appearing on behalf of the state, let a copy of this order be communicated to the Office of Learned Advocate and also to the counsel for respondent number 1 to 4.
They appeared on the last day, but
They are not here. Date तो उनको पता होना चाहिए ना.
date
4th में. तो फाइनल डिस्पोजल में नहीं डाल रहे हैं, सारे एडमिशन हियरिंग पे आएंगे, सब बिलो द लिस्ट रहेंगे, बट एटलीस्ट इट विल बी इन द मेन स्ट्रीम.
ये को stay as constructing the house. That's why. Otherwise, but we are ready. Whatever the date she gives.
4th में.
Item 33, FA 237 of 2024.
Leadership according to the order dated 9 December 24, notices had to be issued to all the respondents. Wherein your leadership respondent number 1 has received and also appeared to wakalatnama. Respondent number 2, 4 and 6 has received the notice.
8 has died.
8 has died and we need to file the substitution notice.
Lordship, I am recommending on behalf of a dependent number Kiran Gupta. Your Lordship, earlier date we have received notice, but we have not received the copy of letter.
मिला दीजिए उनको.
Sure, Lordship, we will give the copy.
आप ले लेंगे इनसे. Counsel for the. You are representing respondent number 1 only. Yes.
Yes.
Also for the appellant and respondent number 1 are present. As per the office note, the notice has been served upon respondent number 1, 3, 7 and 10, 2, 4 and 6, 5 and 9. Either upon themselves or through their close relative, the learned counsel for the appellant submits that the notice will be accepted as validly served. Considering the submissions, the notice is accepted as validly served. Respondent number 8 has been reported dead. As by the office order dated by the office note dated 22/7/2025. Apparently, the proceeding has abated in connection with respondent number 8. Counsel for the appellant seeks adjournment. कब बताइए? अवेट हो चुका ऑलरेडी. डेट बताइए कब रखना.
After 2 weeks.
At the request of the counsel for the appellant, post on 27th April.
Item 34, FA 43 of 2025.
Appellant absent. Next. Next Wednesday.
Item 35, FA 45 of 2025.
Yes, please.
Your Worship, as per service report, respondent number 1 to 4 and 7 to 9 received the notice and went to Jharkhand, whereas respondent number 5, 6, 11 and 12 have received from their family members. For respondent number 10, 13, 14, the report is compared to the house is locked and copy has been received.
Counsel for the appellant and respondent number 1 to 4 and 7 to 9 are present. Counsel for the appellant submits that so far as other respondents are concerned, they have been served either personally or through their close relative, except respondent number 10, 13 and 14. Correct?
Yes.
He submits that the house of respondent number 10, 13 and 14 was found locked and therefore the notice could not be served. He submits that so far as other respondents are concerned, the notice be accepted as validly served. Considering the submissions, the notice upon respondent number 5, 6, 11 and 12 is accepted as validly served. The respondent number 1 to 4 and 7 to 9 have already appeared. So far as respondent number 10, 13 and 14 are concerned, the counsel for the appellant is directed to take press steps for service of notice upon them through the concerned police station for which recusal should be filed within a period of 2 weeks from today. Post on 4th May against service.
Item 36, WPL 7703 of 2025.
Notice could not be served to the respondent, therefore I
IA number?
3576.
IA number 3576 of 2026 has been filed by the petitioner seeking substituted service of notice upon respondent number 3. He submits that in spite of best of efforts, the notice could not be served. And respondent number 3, as per his address, is a resident of Ranchi. कोकर और डिस्ट्रिक्ट में झारखंड लिखते हैं तो हम क्या समझें? डिस्ट्रिक्ट रांची कहाँ लिखे हैं? आप रिस्पोंडेंट के नाम में कहाँ लिखे हैं? Considering the submissions, the prayer for substituted service of notice through newspaper is allowed. The notice be published in newspaper Prabhat Khabar, Hindustan and Telegraph. Hindustan and Hindustan Times. Hindustan Times तो हम तो आजकल लगता है देखे भी नहीं है बहुत दिन से. Telegraph. Hindustan in Hindustan and Telegraph. Hindustan Hindi, Telegraph English. Having circulation in Ranchi. The draft notice for publication be filed by the petitioner within a period of 1 week. Within a period of 2 weeks, the office is directed to provide the notice for publication to the counsel for the petitioner within a period of 1 week thereafter. The Petitioner is directed to file the newspaper publications. Latest by 4th of May. 4th May. Goes this case on 10th of June. आइए ना
Item 37 FA 6 of 2026.
Yes. At the request of the Council for Jharkhand, court is dismissed. कोई खास बात है क्या? आइए फाइल हुआ लिमिटेशन नोटिस हुआ है?
नहीं नोटिस नहीं
आइए पर
नहीं नोटिस नहीं डिले है जो कोर्ट वाले ऑफिस इधर उधर सब
देखिए नोटिस करते हैं कितने लोग हैं?
एक ही क्या
से ह्यूज अमाउंट
इसीलिए थोड़ा
तब क्यों डिले होता है?
इसीलिए आपको सेटिस्फाई करना थोड़ा इसीलिए आप
नोटिस करके सुनेंगे।
ठीक
आइए नंबर 13700 of 25 issue notice to the respondent in the interlocutory application seeking condemnation of delay for which requisites through speed post and ordinary process be filed by the appellant within a period of 1 week. Preemptive. 1 week preemptive. Post on 28th April, awaiting service. Office to track speed post delivery. आपका 2 केस DFD हो गया। ऐसा आइए फाइल करके मत छोड़िए आप लोग। मेंशन करते हैं आप तो हम सेम डे भी नोटिफाई कर देते हैं। ऐसा नहीं है कि आप आइए फाइल करके छोड़ दीजिए उसके बाद बस सोचते रहेगा। This can never happen because office or you yourself have no jurisdiction to extend the time which has been fixed by the court. नहीं, file an application for what? आप for condemnation of for in connection with one or the other defect ना? क्या मतलब है? आप अपना preemptive उसमें सिर्फ preemptive टाइम था आप उसको अप्लाई कोर्ट फीस नहीं फाइल किया।
कोर्ट फीस के लिए एक्सटेंशन के लिए टाइम होगा।
आप तो पिटीशन फाइल करके प्रेस नहीं करिएगा तो कैसे? आप मेंशन यहाँ पे हम तो एब्सेंट भी नहीं रहते हैं इतना। मेंशन करते तो हम तुरंत लिस्ट करा।
आप कल ही अपने हम खुद उसमें रेट में देखें कल
उसमें आपको फाइल ही करना पड़ेगा लिस्ट।
29 में
अच्छा भी नहीं लगता है।
नहीं हमको भी लगा हम भी कल
आइए फाइल करिए तो मेंशन करिए हम तो सेम डे भी लिस्ट करा देते हैं वैसा अर्जेंसी हो तो नेक्स्ट डे तो कर ही देते हैं। 29 को
आइए फाइल के में
हम नहीं थे तो क्या होगा? आपका अपीयरेंस थोड़ी रिकॉर्ड कर देंगे। लिटिगेंट को रिलीफ दिए आपको नहीं। चलिए एब्सेंट थे तो एब्सेंट ही मार्क।
Order reading for final disposal. Item 22 FA 73 of 2020.
चलिए प्लीडिंग्स आर नॉट कंप्लीट। एफए में क्या प्लीडिंग्स का रिकॉर्ड तो आ गया होगा। टाइम के अलावा आपको क्या चाहिए बस उतना बता दीजिए। टाइम हम नहीं देंगे। चलिए आर्ग्यू योर केस। आईए क्या चीज का आईए?
I was filed
For what?
to immediate
the subsequent purchaser as a this one number 3.
Not required.
That has been allowed, and notices were ordered to be issued, but still nobody has appeared on behalf of.
Let them not appear. Notice service complete हो गया ना? सर्विस कंप्लीट हो गया कि नहीं? वो तो क्या, उससे कोई मतलब नहीं है। आइए तो क्लोज हो चुका है। क्लोज हो चुका है, देयर इज नो आईए पेंडिंग। लिस्ट में कोई पेंडिंग आईए दिख रहा है? नहीं नहीं, इट इज ऑलरेडी क्लोज्ड। आईए इज क्लोज्ड। 8386 ना? इट इज क्लोज्ड। आप आर्ग्यू करिए अपना केस। टाइम नहीं देंगे सर, हम बहुत कॉस्ट लगा देंगे हेवी। हाँ तो पढ़िए, यू आर्ग्यू योर केस।
हमको लगा कि इसमें नहीं हुआ।
अब आपके लगने से तो चेंज नहीं हो जाएगा ना सिचुएशन। यू आर्ग्यू योर केस। आर्ग्यू योर केस। दिस इज सूट फॉर स्पेसिफिक परफॉर्मेंस। आर्ग्यू। एडमिट कैसे नहीं हुआ? एडमिट नहीं हुआ अभी तक। एडमिटेड है कि नहीं? एडमिटेड है। I am just absolutely clueless. I have no words to say. Will you argue your case or I will dismiss this case?
No.
Argue.
So, the suit is for specific performance after I received the judgment. We are doing what happens in a very peculiar circumstances. The judgment doesn't pass for the long court, but during the pandemic period, COVID-19. And in this case, what happens? The defendants did not act. The court below proceeded expertise against the defendant, and finally the suit has been defeated in part.
Yes. Decreed in part.
Decreed in part.
Decreed in part means?
Decreed in part, so far the allowing the
there is a direction to refund
of rupees 6,30,000, which was paid in advance in person of the contract. Dated 5/7/2016, and so far we have for specific performance of agreement dated 5/7/2016 is hereby received.
Yes.
Case of the plaintiff appellant is that he was ready and willing to purchase the land by paying the less amount, 28 lakhs was fixed total.
What is the date of agreement? Date of agreement?
Date of agreement is 5/7/2016.
5/7/16. Exhibit number? Exhibit?
Exhibit number 1.
Exhibit 1. Okay. What was the date prescribed?
The date prescribed 16 months.
16 months. When did it expire?
It expired. That was
7/11/2016. When did you file the suit?
It was filed just after that. Uh, 20
26 to
26
2018.
26 to 2018.
So according to you, the suit was within limitation. There is no finding on limitation also. Now you tell me readiness and willingness. Where is your averment that you are ready and willing to perform?
Yes.
What was the amount paid initially? What was the total consideration?
Total consideration was 28 lakhs.
28 lakhs.
6 lakhs 30,000.
6 lakh
30,000 was paid.
36.3 lakhs paid.
Yes. And that
Balance कितना हुआ? Balance?
21 lakhs.
How much?
21 lakhs.
21 lakhs 72.70 lakhs. Okay, where is your averment on readiness and willingness?
Yes.
Plain से दिखाइए. Plain से दिखाइए. Plain.
Yes.
There is no averment regarding availability of fund.
Well, that has been the finding has been given on that, but
There is no averment regarding availability of fund.
But the documents, but it has been listener has filed 7 documents that he has sufficient fund his father.
Where is which exhibits? Which all are the exhibits?
Exhibit, let me see. From exhibit 4 to 4E.
Exhibit 4. You see, under the law you have to plead and prove both. Pleading तो है नहीं.
That is the oral argument. The prisoner has established his case.
Oral argument से नहीं होता ना.
That
Where is the foundation
Yes,
pleading?
his father has also before.
There is no foundation pleading. Where was the money?
Court below, but as discuss these things, other ideas, document evidence. In courts of evidence, they can prove number of documents on provision of 5, 6, 7 respectively. It appears that these documents are related to the title of the
अब पैरा 13 पढ़िए.
Para 12.
You read पैरा 13. One.
12 में
12 में it says that the agreement is valid. Let's take it. Agreement is valid.
In the following discussion,
So far as readiness, para 13.
so far as readiness and willingness on part of the country is concerned, it appears that the country was willing to purchase the land as he given rupees 6,07,000 as an advance in pursuit of the agreement, and also participated in measurement and demarcation of the civil land as the land was vacant. But payment of balance compensation amount was one of the amount and precondition for the enforcement sale in favor of the debt. On the result of the order and documentation, it appears that although the party does try to show the jointness and unity among his family members, but it is very much clear that the agreement was made in the sole name of the party. His father has been told that I have sufficient money, I will help my son to purchase the land, to manage the fund. So it has been denied to accept. Further appears that no income tax return has been filed and proved by the country for the resident resident, and it is admitted by the plaintiff himself that he had only 8-9 lakhs rupees. Remaining amount he could be paid with the help of others. In the following discussion, it appears that as per the agreement, 16 months was with us on 4/11/2017. On result of 4, it appears that the plaintiff has also tried to show bank balance remained in the bank account of the family members, and on this meticulous perusal, it appears that in the account of increasing the balance amount of in the month of November 2011, the balance amount is 5,07,731 in and another account by the exhibit 4/4A of increasing. Balance amount will be 6,40,000 of 807 on dated 18/12/2017. I kindly appreciate at the same time that the period was the pending period. So people, that is the situation, and in that situation the case has been finally heard.
It makes no difference. Evidence has been led.
No. So currently managing the fund by the plaintiff. So that was also a tremendous job for that time.
कोविड पीरियड में थोड़ी कोविड पीरियड तो 2020 में शुरू हुआ. कोविड पीरियड has started in 2020. The suit was filed in 2018. You have to show your readiness and willingness throughout. You have not been able to show your readiness and willingness. The fund is not available with you. आपके पास 2000 की 20,000 रुपए है, आपको 28 लाख का प्रॉपर्टी खरीदना है. There is no foundation pleading in your plaint also.
The plaintiff PW1 has stated in paragraph 7 that he made a phone call to the defendant to receive rupees 22 lakh.
कहाँ है 22 लाख? हवा हो गया. कहाँ चला गया?
But he has also stated that he had only rupees 8-9 lakhs.
BW2 has stated that in his cross-examination in class 16 that they want to give rupees 22 lakhs in September 2017, but the defendant told that they will receive the amount in the at the time of registration, whereas it is stipulated in the agreement itself that on receiving the
You show me that on the date of the agreement, or even on the date of the agreement, or even subsequently, or even when it matured, 21.70 lakhs was available to you. कहाँ है?
BW3 has stated in paragraph 12 that the defendant were not come to the plaintiff to receive the remaining compensation amount. As per the case of the plaintiff itself.
Mr. Mukhopadhyay, please listen to me. If the defendant did not come to receive the money, that is why the suit for specific performance of contract was filed. Show me 22 लाख रुपए कहाँ है? आप दिखाइए, आपको डिग्री देते हैं यही, बताइए 22 लाख रुपए कहाँ है? आपके पास था? आप कैश लेके गए थे इनके पास, चेक लेके गए थे,
6,30,000 तो
वो तो हो गया ना। उसके बाद 22 लाख रुपए तो देना था ना।
21,70,000
कहाँ है आपका 21,70,000? अब जितना भी बैंक अकाउंट प्रोड्यूस किए हैं वो सबमिट कर भी 21,70,000 नहीं होगा। दिस इज ओवर एंड अबव द फैक्ट कि आपका कोई प्लीडिंग नहीं। ठीक है, इसमें क्या गलत है? एकदम ठीक है, ऑर्डर में क्या गलत है?
So what the finding that the plaintiff fails to establish that he has sufficient fund to pay the remaining compensation amount for the 80 lakhs of the to the time period of the week. If he was in readiness, why the compensation amount was not paid as per the years moved to the defendant. Therefore, find that the plaintiff fails to miss the week on the basis of
आपको क्या बोलना?
Steve.
12 and one judgment degree may be cited. And a subsequently discussion has judgment, as per judgment, what is required for especially performance.
Yes, Mr. Mukhopadhyay, do you want to place any of the oral evidence or any of the documentary evidence to show that this finding is incorrect? Do you want to place any oral or documentary evidence? बताइए कौन कौन सा ओरल और कौन कौन सा डॉक्यूमेंट्री एविडेंस आपको प्लेस करना है? यू जस्ट टेल किसका किसका ओरल और किसका किसका डॉक्यूमेंट्री प्लेस करना है। फर्स्ट अपील है ना। अब घड़ी इतना मत देखिए, हम 2 बजे तक भी बैठ जाते हैं। बताइए क्यों, कौन सा ओरल एविडेंस प्लेस करना चाहते हैं? किसका किसका प्लेस करना चाहते हैं? You see, is there any error in discussing the evidence by the learned court? कुछ error किया है कि 2 लाख की 20 लाख की जगह 2 लाख लिख दिया है, ऐसा कुछ किया है क्या? ऐसा तो नहीं किया ना। फिगर फैक्ट एंड फिगर तो सही लिखा है, चीफ एंड क्रॉस भी सही लिखा है। किसका एविडेंस आप प्लेस करना चाहते हैं? प्लेट में क्या एविडेंस प्लीड होगा? आप हमको बताइए।
BW1 plaintiff himself, but how here? Page 7 of the
Yes, sir.
one, the plaintiff himself has
supported the case stated that the agreement for sale was negotiated between plaintiff and the defendants of 5/7/2016, and the said land was purchased by the defendants. Right, registered number 93 of 2016, dated 28/7/80. He further stated that the price of the scheduled land was decided and the tune of the goods were paid. He paid ₹5 lakhs on 8/7/2016 to RTGS as an advance. He further paid ₹1,30,000 on 20th July 2016 to RTGS and NEFT in the account of the defendant one, and as such he paid altogether 6,30,000 as an advance out of consideration amount of 28. He further stated that the scheduled land was demarcated and measured on the application of defendant two, and by order of the legal circle officer 14/7/2017 stated that despite his several requests, the defendants who were preferred to transfer the scheduled land till 31st December 2017 and shifted 300 kilometers far away from Sanpar. He further stated that on 12/2/2018 he sent a legal notice to the defendants, and despite received the legal notice, no step was taken on the defendant to transfer the land, thereby the plaintiff was bound to file this case. During cross-examination, he stated that his supplier of bitumen and sand for last 8 years, and he filed income tax return in the year 2016, 16-17, respectively, with 7 lakhs, 5 lakhs, respectively. He admitted that as per agreement, the land was to be transferred to registered sale within 16 months, and despite several requests remaining 22 lakhs rupees were not received by the defendant. In the 8 of 2016, he stated that he had 22 lakhs to pay the due consideration amount. Simultaneously, he has also stated that he had only 8-9 lakhs, and he could have borrowed the remaining amount from others. PW2 is the brother of the defendant. He also supported the assertion plaintiff that out of 28 lakhs, 30,000 was paid as an advance by the plaintiff. They stated that still the plaintiff is willing to purchase the said land. Further, he took the account statement of plaintiff and deposits in the name of the plaintiff account at Bank of India, joint account SBI, in the name of the plaintiff and his father. Account statement in the name of Rinki Singh and fixed deposit in the name of Rinki Singh. During prosecution, he stated that no partition took place between him and his father. He further stated that 16 months time was to be completed in November and December 2017. In the stated that the want to give is 22 lakhs to the defendant, but the defendant told him to receive the amount at the time of registration, and the agreement is not ready. Because the chief, who is the father of the defendant, has also said.
इसको पढ़ के आप क्या कर रहे हैं?
नहीं, इसमें पैसा registration समय registration.
अरे पैसा कहाँ है? बताइए ना।
पैसा तो
भाई जितना बैंक अकाउंट प्रोड्यूस किए सब जोड़ के भी 22 लाख नहीं हो रहा।
What happens? यहाँ रजिस्ट्रेशन जब रजिस्ट्रेशन होगा हम लोग देंगे।
कहाँ से दे देंगे?
तो रजिस्ट्रेशन कर नहीं रहा।
कहाँ से दे देंगे? आप you gave your statement You gave your statement that you were ready with the money and the plaintiff was not and defendant was not taking the money from you. Where is that readiness? कहाँ है पैसा?
They had intention not to register this sale deed.
They had no intention to register the sale deed. That is why the sale deed has to be registered through the process of court. Where is the money?
Respondent one during pendency of the suit has.
Where is the money?
What? How?
I'm asking you, where is the money? I will give you specifically. Where is the money? 22 लाख रुपए दिखाई, कहाँ है एविडेंस? सब मिला के भी नहीं है, आपके पूरा फैमिली मेंबर्स का, एक्सटेंडेड फैमिली सबका बैंक अकाउंट मिला के भी 22 लाख रुपए नहीं है. चलिए.
आधा जमीन बेच दिया, दूसरा कागज में शिफ्ट कर गया, 300 किलोमीटर अवे.
भाई वो बेच दिया समझ आ रहा है. आप अपना रेडीनेस एंड विलिंगनेस दिखाइए ना, तभी ना डिक्री होगा. उसके बिना कैसे डिक्री होगा?
आधा पैसा तो जमीन के अनुसार तो आधा पैसा
नहीं, अब आधा पैसा नहीं होगा, पूरा ही पैसा होगा. स्पेसिफिक रिलीफ पार्ट पार्ट का नहीं होता है, तो पूरा जमीन का होता है या नहीं होता. चलिए सुन लिया. आपको क्या पता? स्टेटमेंट ऑफ brother, father, everything is there. Where is the money? Show me the color of the money. Arranged.
What they told the Jameson at the time of registration, but he was not willing to get the.
You said that you approached him with 22 lakhs and he did not accept it. Where is that money?
The applicant was told that at the time of registration we will give the money.
आप अपना एविडेंस देखिए ना. आप अपना एविडेंस में क्या PW1 का ही स्टेटमेंट.
वही तो है कि रजिस्ट्रेशन इनका जो फादर है, ब्रदर है, सिस्टर है, सब they depose in the same line कि at the time of registration they will help the applicant with by supplying that amount. But they 300 किलोमीटर दूरी पर शिफ्ट.
पैरा नंबर 13. यह कि प्रतिवादी गण को बार बार एकारानामा के शर्त के अनुसार केवला दलील संपन्न करके बाकी रकम लेकर रजिस्ट्री करने का अनुरोध किया और ये मना कर दिया. Where is the money? Heard the learned counsel.
दो भाई में से एक भाई का डेथ हो गया, जमीन बेच भी दिया था उसके पहले पेंडेंसी तो and they did not they were not ready to establish the deed.
Heard the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant has submitted that the suit for specific performance of contract has been partly decreed in as much as the prayer of specific performance has been refused, but a direction has been issued upon the defendant to refund the amount of rupees 6 lakhs to the 6 lakhs 30,000 to the appellant with interest.
It was paid in advance.
Which was paid in advance through banking transactions. The learned counsel has submitted that
with 6% interest.
With 6% interest. The learned counsel for the appellant has submitted that all the witnesses have duly supported the case of the plaintiff and the money and the balance amount of rupees 21,70,000 could have been arranged by the plaintiff with the help of his family members. But this aspect of the matter has not been properly considered by the court, and therefore the impugned judgment calls for interference. We have submitted that even the father of the plaintiff was examined as witness, and he has also supported the case of the plaintiff the learned counsel submits that under such circumstances the suit was required to be decreed. He has also submitted that the part of the property has been sold to a third party who has been made during the pendency of the suit, and he has been made a party respondent in the present proceedings.
He died.
But he died. कहाँ है? He died.
Defendant number 1.
And thereafter the defendant number 1 died.
One of the real heirs, the daughter, has a
And only one of the daughters हैं, Usha Devi.
3 daughters of the defendant number 1 were substituted. Out of that, Usha Singh has only IA number 6669.
He submits that the daughters of defendant number 1 were substituted, and only one of the defendant has now appeared. One of them has appeared before this court. The learned counsel for the respondents has submitted that
another IA was 5 minutes, there was allowed subsequent purchase. She was.
That's right.
Singh was.
That's right, it is not required. The learned counsel for the respondents has opposed the prayer and has submitted that every evidence placed on record has been taken into consideration. He has also submitted that there was neither any pleading nor any evidence placed on record to show the readiness of the plaintiff to pay the balance amount of consideration. He submits that though a finding has been recorded with respect to willingness on the part of plaintiff to buy the property, as he had deposited the earnest money, but upon consideration of evidences placed on record, it has been held that he was not ready to perform his part of the contract. And the availability of the fund or the source of fund could not be proved by the plaintiff. He has also submitted that there is no perversity in the matter of appreciation of evidence, and the judgment is well-reasoned judgment, which does not call for any interference.
So, but my one thing that the applicant has stated that only due to the reason that they went on referring the date of registration, and they left the place and shifted to 300 kilometers away from, and they we complete the appellant to submit to send a legal notice. Still, they have neither come to register the document.
The learned counsel for the appellant in response has submitted that the plaintiff was throughout ready and willing to perform his part of the contract, but the defendants, they shifted to another place in West Bengal, and in spite of legal notice, they were not ready to execute the sale deed.
And on the other hand, this one of the defendants.
And on the other hand, one of the defendants sold his half share of the property during the pendency of the suit. That's it. That's all. Yes, Mr. Mukhopadhyay, that's all.
Yes, yes, yes.
मेरे साइड से एक बात यह है कि उनके कंसेंट से इन्होंने कंसेंट देर आफ्टर आई
From where do I get this? जो चीज रिकॉर्ड में नहीं है वो नहीं कर सकते ना. जो चीज रिकॉर्ड में नहीं है वो चीज से मत बोलो. कहीं आया है एविडेंस में कंसेंट से बेचे नहीं आया है ना.
Another circumstance is the part of the amount which was allowed by court below. So that who is to pay? Nobody has only one daughter of number one.
आप एग्जीक्यूट करिए ना. एग्जीक्यूट करिए आप. डिसमिस्ड. हम दिखा देंगे चेंबर में.
जजमेंट में